Welcome back to the deep dive. Today we're opening a file that, honestly, it tells a story of broken promises, some staggering numbers, and a literal hole in the ground that completely changed how we think about contracts.
It really is one of the most famous holes in legal history. And it forces you to ask, what is a signature on a piece of paper actually worth?
We are talking about the landmark case of Peevyhouse v. Garland Coal and Mining Company, a decision from the Oklahoma Supreme Court way back in 1962. And to set the stage, I want to give you a math problem that gets right to the heart of this. It's the battle of the $300 hill versus the $29,000 hole.
That is the perfect way to frame it. It's a fundamental problem in contract law. If you promise to do something in a signed agreement and you break that promise, do you have to pay what it costs to fix it? Or do you only pay what the finished product is actually worth on the market?
It feels like those should be the same thing. I mean, if I break a window, I pay to fix the window. Simple.
You think so, but as we're about to see, in the eyes of the law, cost and value can be two completely different things.
Not even in the same ballpark.
Not even close. So here's our mission for this deep dive. We're going to map this whole conflict out. First, we need to define the standard way the law measures damages when a contract is breached. This is the concept of expectation damages.
Okay, starting with the basics.
Exactly. Second, we're going to dive into a doctrine called economic waste and the relative economic benefit test. This is where it gets messy. Third, we're going to apply these rules to the Peevyhouse case, step by step. And finally, we'll put it all together into a diagnostic checklist, a sort of protocol, so you can spot this issue if you ever run into it.
I do love a good checklist. But let's start with the rules. Before we get into the coal mining, what's the general rule for damages when someone messes up a construction or a mining contract?
The black letter law, the standard off-the-shelf rule, is that the injured party is entitled to be put in the same position they would have been in if the contract had been performed. We call this expectation damages. You expected a certain result, so the law tries to give you that result, or at least the money to get it.
So if I hire you to build a brick wall in my garden, and you just don't show up, you owe me the wall.
In essence, yeah. And the primary way we measure that is the cost of performance. The court looks at what it would cost to hire someone else to actually do the work, to build that wall, and they award you that specific amount.
That seems fair. Contract says build a wall, damages should be the price of building the wall. Why would it ever be anything else?
Right, that's the starting point. But like always in the law, there's a conflict. The sources point to a competing rule called the value rule, or diminution in value. And this rule says, well, maybe we shouldn't pay you the cost to build a wall. Maybe we should just pay the difference in the market value of your property.
Hold on. So if the wall would only add, say, $10 to my property value, but it costs $1,000 to build under this value rule, you'd only owe me the $10.
That is the core of the economic waste doctrine. The Restatement of Contracts, Section 3461, makes this really critical distinction. It says cost of performance is the right measure unless.
Ah, here it comes, the unless.
Unless doing the work would involve unreasonable economic waste. If the cost is just, grossly out of proportion to the benefit, the law might shift to the value rule to avoid what it sees as a complete waste of resources.
Okay, so we have the general rule, cost of performance, and the exception, economic waste. Let's see how this actually played out with real people. Let's dig into Peevyhouse v. Garland Coal and Mining Co., using that structured framework you mentioned. So first, what are the legally dispositive facts?
So here's the situation. The plaintiffs were Willie and Lucille Peevyhouse. They owned a farm in Oklahoma. And in 1954, they leased that farm to the defendant, Garland Coal and Mining Company, for 5 years.
And this wasn't just some handshake deal.
Oh no, it was a very detailed, written lease for strip mining. Garland Coal was going to dig these huge pits on the surface to get the coal out. But the Peevyhouses, they were smart. They knew strip mining just destroys the land, so they insisted on very specific protective clauses. Clauses 7B, 7C, 7Vs, and 7F.
And what did those clauses say the company had to do?
They were remedial covenants. The defendant agreed that after the mining was done, they would fill in the pits, they would smooth out the spoil banks, which are just these ugly, dangerous piles of waste dirt, and remove all the shale and debris. Basically, the contract said, you can mine our land, but you have to put our farm back together when you're done.
And I'm guessing Garland Coal didn't do that.
You guessed right. That's the breach. Defendant mined the coal, took their profit, and then flat out refused to do the remedial work. They just left the pits open and the piles of dirt everywhere.
So now we get to the numbers. This is where the math just gets wild.
It's staggering. At trial, experts testified that the cost of performance, The actual cost to move all that dirt and fix the land like they promised was roughly $29,000.
Okay, $29,000. In 1962 money, that's a huge sum. That's like the price of a couple houses back then.
It's a fortune. But then the defendant's lawyers came in with their own evidence.
Mm.
They showed that if they did spend the $29,000 to fix the farm, its market value would only go up by about $300.
Wait, say that again. Spending $29,000 to fix the land would only add $300 to the farm sale price?
That's right. The farm was in a remote area. The real estate market at the time, it just didn't care if the land was flat pasture or a bumpy, scarred-up strip mine. So the jury, they were confused. They ended up awarding $5,000, sort of splitting the difference. But both sides appealed to the Supreme Court of Oklahoma.
Right, because the Peevyhouses wanted the full $29,000 to fix their farm, and the coal company thought even $5,000 was way too much.
Exactly.
Okay, so if we're going to analyze this like lawyers, what was the core legal issue?
The issue was, should the measure of damages for breaking a promise to fix land be the reasonable cost of performance, the $29,000, or should it be limited to the diminution in market value, the $300, when that cost is so grossly disproportionate to the benefit?
It all comes down to the $29,000 versus the $300. So what rule of law did the court apply here? Can you state the full rule and break it down into its testable elements?
The court adopted a limiting rule based on something called relative economic benefit. And to limit the damages to just the diminution in value, the court laid out a test with two very distinct elements. Element 1, the part of the contract that was broken must be merely incidental to the main purpose of the contract. And Element 2, the economic benefit of full performance has to be grossly disproportionate to the cost of that performance.
Okay, let's slow down here because this is where the whole thing turns. Let's go through the court's elemental analysis step by step. How did the court apply that first element, the incidental test?
This is probably the most controversial part of the decision. The sub-issue here is, was fixing the land the main point of the lease, or was it just a side note? The court looked at the contract and said the primary object was the economical recovery and marketing of coal.
So the main point was digging up coal to make a profit.
Right. And since the main goal was industrial mining, the court reasoned that the clauses about fixing the land afterwards were secondary. They were, in the court's words, merely incidental to the main event.
I have to stop you there. That sounds really debatable. If I'm a farmer, isn't the condition of my farmland pretty central to, my life?
You just made the exact argument that the dissent made. Justice Irwin wrote a powerful dissent, and he argued that the plaintiffs, the Peevyhouses, specifically negotiated for these terms. They would not assign the lease without them. To them, these clauses were not unsettled, they were essential. But the majority saw it differently. They concluded that element 1 was met. The provision was incidental.
Okay, so the court says fixing the land wasn't the main point. Got it. What of the second element, gross disproportionality?
This is where they just did the math. The sub-issue is whether the cost relationship is conscionable or, reasonable. The court looked at Oklahoma law, specifically a couple of statutes that basically say you can't get damages that are way more than what you would have gained, and you can't have unconscionable damages.
And how did they apply that to the two numbers, the $29,000 and the $300?
It was a straight comparison. Cost to perform, $29,000.
Yeah.
Value gained by the property owner, $300. That's a ratio of almost 97 to 1. The court just saw that as unreasonable economic waste. It basically said, we're not going to force a company to spend $29,000 to create a $300 asset.
So they decided the cost was grossly disproportionate.
Yes. They found element 2 was met.
So after analyzing both elements, finding the work was incidental and the cost was disproportionate, what was the court's final conclusion?
The Supreme Court of Oklahoma modified the judgment. Since both elements of their new test were met, they just tossed out the cost performance measure completely. They limited the damages to the diminution in value.
Which means
they reduced the jury's $5,000 award down to exactly $300.
Wow. $300. They essentially let the coal company walk away from a $29,000 promise for the price of a fancy dinner.
A very fancy dinner in 1962, but yes, the Peevyhouses were left with a destroyed farm and $300, which wasn't going to fill a single pit.
That is just such a jarring precedent. To really lock this idea of economic waste in our heads, let's use a hypothetical. The sources bring up a classic case about granite foundations. Let's play that out because maybe the rule makes sense sometimes.
Absolutely. This is the classic wrong kind of granite scenario, inspired by the logic in a case called Jacob and Young's v. Kent. So imagine you hire a contractor to build your dream mansion. The contract is super specific. You must use Coosa Creek granite for the foundation blocks.
Okay, Coosa Creek granite, the best there is. Got it.
The contractor builds the mansion. It's perfect. Structurally sound, looks beautiful. But he made a mistake and used Blue Ridge granite for the foundation instead. Now here's the kicker. The two types of granite are chemically identical. They're the same strength, same quality. And once the house is built, the foundation is completely underground. You can't see it.
So I have a perfect house, but the rock buried in the dirt has the wrong name on it.
Exactly. So you sue. You say, I want what I paid for, tear it down and do it right. But to perform the contract now, the contractor would have to demolish the entire mansion, dig up the foundation, and rebuild everything. It would cost millions of dollars.
And what's the difference in the home's market value?
Zero. Absolutely zero.
Yeah.
The house is worth the exact same amount with either granite.
Okay, in that case, ordering the contractor to tear down a multi-million-dollar mansion seems insane. That feels like actual economic waste.
Right. It destroys millions in value for no functional gain whatsoever. In that scenario, almost any court would say, look, you got a perfectly good mansion, the difference of value is zero, here's $1, now move on. That's why the doctrine exists, to prevent that kind of spiteful destruction.
But, and this is a big but, in Peevyhouse, the ugly spoil banks were visible. Leaving a farm destroyed isn't the same as using the wrong invisible granite under a house, is it?
And that's the $29,000 question, isn't it? In the granite hypo, the result is a useful, beautiful house. In Peevyhouse, the result is a scarred, unusable farm. And this really highlights why the decision is so controversial. The court effectively treated fixing the land as wasteful just because the real estate market didn't put a high price tag on the repair.
It's like saying if the market doesn't care that your family farm is ugly, then the law doesn't care either.
It implies that the owner's personal, aesthetic, or even sentimental value doesn't count if it doesn't show up on a real estate appraisal.
That is a tough pill to swallow. But we need to be able to spot this, right? In an exam or a real contract dispute. So let's synthesize this. How do we turn this into a checklist?
Okay, we can call this the Peevyhouse protocol. If you're looking at a situation like this, just follow these 5 steps.
Step 1.
Identify the breach. Is the problem a failure to perform some kind of remedial or construction work? Did someone fail to build something or fix something they promised to fix?
Okay, step 2.
Determine the default measure. You always start with cost of performance. That's the default. The person who broke the promise has to prove why they shouldn't have to pay it.
Step 3.
The economic waste filter. Now you ask the math question. Is the cost to fix the problem massively higher than the increase in the property's market value? If the answer is no, you stop. You award cost of performance. If the answer is yes, like $29,000 versus $300, then you go to step 4.
All right, step 4.
The main purpose test. This is the big one.
Yeah.
Was the broken promise the main reason for the contract, or was it just incidental?
And how do you tell the difference?
You look at intent. If I hire you specifically to landscape my yard, that's the main purpose. In that case, you'll probably get the cost of performance no matter what it is. But if it's just a cleanup clause in a huge industrial contract like in Peevyhouse, a court might say it was incidental. And if it's incidental, damages get limited to diminution in value.
And what's the last step? Step 5.
Check for bad faith. Let's call this the dissent factor. Remember, Justice Irwin argued that Garland Coal's breach was willful. They knew what it would cost, they took the coal, and then they just decided not to bother with the cleanup.
Does acting in bad faith change the outcome?
In some places, it absolutely does. The sources mention a Minnesota case, Groves v. John Wonderco. There, the court said if the breach is willful, we're not going to let the bad guy profit from their own wrongdoing. They awarded the full cost of performance, basically to punish the breacher and stop them from getting away with it. So you always have to ask, was this an honest mistake, like the wrong granite, or was it an intentional choice, like refusing to fill the pits?
That's a huge distinction. And it feels like the Peevyhouse court just ignored the bad faith part and focused only on the cold, hard math.
They did. They put economic efficiency on a pedestal, right above the moral weight of a promise.
So let's bring it all home. What does this mean for us today? It seems like Peevyhouse stands for this harsh reality that sometimes the law cares more about economic efficiency than the sanctity of your word. A contract isn't always a guarantee you'll get what you were promised.
That's the cynical but probably accurate takeaway. Sometimes a contract is just a menu of prices for breaking it. You can do the work, or you can pay the damages. And if the damages are cheap enough, a smart company might just choose to pay.
It's the whole idea of efficient breach. Garland Cole probably did the math and realized it was cheaper to fight a lawsuit and pay a few $100 than to actually bring the bulldozers back.
And that raises the final provocative thought I want to leave you with.
Hmm.
Think about what happened here. The court said, we won't make you spend $29,000 because the market says the repair is only worth $300. But by doing that, by limiting the damages so drastically, did the court effectively just rewrite the contract for them?
How do you mean?
Well, the Peevyhouses gave up the right to their land in exchange for two things: royalties and the promise of repair. By erasing the repair part of the deal, the court allowed the coal company to essentially get the use of their land for pennies on the dollar. The company got all the valuable coal, and they didn't have to pay the full price they agreed to.
It's a wealth transfer from the farmer to the coal company with the judge's signature on it.
Precisely.
That is definitely something to think about next time you sign a contract. You got to look at those clauses at the end and ask yourself, is this part incidental or is this the whole reason I'm signing? Because the answer might decide if it's a real promise or just a suggestion.
And remember, if the market's numbers don't add up on your side, the law might not either.
Thank you for listening to this deep dive. We'll catch you on the next one.